Good afternoon. How is everyone?
Well, and yourself, Miss Archer?
Oh, I'm well. I'm well. I see everybody is on early, eager beavers. Don't be looking for grades because it's not finished. And we have a few persons who still have to take the test. So hopefully when I speak to you all next week, all the grades would be finished. So how was it anyhow? Let's not talk about it because others have to take it. So we'll wait until next week. But everybody felt like they did okay.
No.
You want us to answer that out loud and publicly?
I'll leave it at
That was the wrong question to ask, Miss R. You said you wanted to leave it and then you pushed. You were wrong for that.
Yeah. Yeah.
Too quiet. Too quiet. But anyhow, I'll see. It may not be as bad, I had a class who thought that they had all failed.
Well,
And they got their grades, they was like shocked. They just felt that they just put down rubbish on the paper, but they didn't.
So, Ms. Archer, let me say this. That is how I feel. Like, I'm not sure that I answered the question. I guess that's my one comment. That's how I was feeling. Like, I'm not sure that what I wrote answered the question, but, I just referred to the cases and I tried to do it based on that.
Let me see.
So I then prayed.
My only concern is you being able to read my penmanship. I haven't written in years.
Okay.
So I hope you can read it. I meant to send you an email to extend my apologies for my penmanship.
Let me see your penmanship. Like I say, haven't finished. Oh God, you write in twice, 3 times on the paper.
Horribly. What do you mean twice or 3 times?
I can
Horribly.
Okay.
And since you're looking at mine, please note that I inadvertently skipped number 4 and put it on the back of a sheet of paper. I put it on the back.
I see the page. Please see number 4 on the back of the page.
Thank you. Okay.
Okay, so I just reading on the others. Because sometimes depend on the answers, I would mark it on the curve, and I don't like to do it. And then when I get another paper later down, I forget like how I allotted the points. So that's why I like to wait to get all of them one time. But okay, who felt just now they did put that? Was Cicely?
Yeah.
Where's your paper? Hold on. I don't have a paper for you. When did you take yours?
It might be at the office on Saturday.
Okay. Okay, that's at the office.
Okay.
Okay. I have to get that along with another one. That's for this weekend. So that's why I say we'll wait until next class.
And excuse me, Miss Archer, did you get an email from me this afternoon?
Yes, I did.
Okay, thank you. Okay.
Yeah, I did. All right, so today we're supposed to talk about 2 things: employee discipline and grievances. But we do have some cases, don't we? For today.
Yes, ma'am.
Yes.
One.
Okay, so everybody read the notes? I hope you say yes.
You mean in terms of what the case is? Oh.
No, the actual in the module 6.
Oh, yes. Yes.
Because all the module does is lay out the more or less the practical format for grievance procedure, and then the thing for disciplinary procedure. But like I said before, I prefer, if you've read the chapter, to let's go through the cases to see how the courts interpret these things. But I think give you a better answer from a practical standpoint in applying employment law in your day-to-day functions. So who wants to go first?
I can go.
Okay, all right.
Okay, so my case is Erica Hall and Battery and Tire. Okay, so this claim was by Mrs. Hall that she was wrongfully dismissed. And she wanted to add into her application, she wanted to expand the claim of the original application to add unfair dismissal. However, the court said that they were only to make a determination on wrongful dismissal only. So Ms. Hall was hired December 1st, 1990 as a cashier, and she was promoted to the account supervisor in 2015. And in late March 2018, she was terminated. Sorry, that is the respondent, which is Battery and Tire, terminated the employment of 3 cashiers. So they named the cashiers on the grounds that they stole funds belonging to the respondents. So the reason for Ms. Hall's dismissal, Ms. Hall was on vacation during the time of these terminations. And when she returned to work, she found that the cashiers were no longer on the premise. So on her second day back to work, which was on the 4th of April, 2018, Ms. Hall was also dismissed without notice. The respondent's position was that Ms. Hall was grossly negligent in the performance of her duties as account supervisor and failing to detect the incidences in which 3 cashiers stole funds belonging to the respondent in a fraudulent scheme. The respondent recounted that Carl McCartney, its manager of inventory, discovered the fraudulent scheme when he reviewed and found discrepancies in the electronic entries of sales transactions in the company's point of sale. Carl McCartney matched these electronic discrepancies with video surveillance footage of the cashier's activities during the time of the discrepancies. The discrepancies were recorded in the system. The respondent's witnesses described one incident amongst others in the recorded video footage in which a cashier removed money from the cash register and rested it above her keyboard to serve customers, then eventually put the funds into her pocket. As a result of the suspicious activities uncovered by Carl McCartney, the respondent believed that there was a fraudulent scheme perpetrated by the cashiers in the way they carried out the sales return processes. The tribunal was given to understand that the alleged fraud was somehow perpetrated when customers returned purchased items in order to get a refund or to exchange a return for another. However, the parties laid out no clear logistical path of the complete steps in the alleged scheme. So the issues for determination are, did the applicant have the duty as account supervisor to oversee the cashier's daily cashing activities so as to detect stealing or fraud perpetrated by them? The second one, did the respondent in its summary dismissal of the applicant act lawfully? And the third one, if it is found the applicant was wrongfully dismissed, to what compensation, if any, would she be entitled? So the tribunal accepts the following. Ms. Hall performed supervisory duties in connection with accounts receivable, but she was ultimately managed by and had to report to Mrs. McCartney, manager of the accounts department of the respondent. Ms. Hall was responsible for calling and urging clients to pay their arrears on their accounts with the respondent. And each of the cashiers also rotated on duty to assist with accounts receivable. They sat with Ms. Hall in her office on their rotation, and she supervised them in contacting customers to bring outstanding accounts current. Ms. Hall's office was a separate enclosed room adjacent to the cashier's work area, but she usually left the door open. Ms. Hall was also required to run a report on aging accounts receivable monthly from the computer system of the respondent. This report was submitted to Mr. Basil Ingram, who was the accountant for the respondent. This is the only account report Ms. Hall was responsible for submitting. So Ms. Hall scheduled the cashier's vacation and personal day request. She filled in for cashiers who were out on break. but never did a full day of cashier's work. She also occasionally filled in for the telephone operator. Ms. Hall was usually present for what the witness called the daily cash drop, in which the funds collected from the cashiers from customers would be double checked in the presence of the cashier, Ms. Hall, and Mrs. McCartney. If Mrs. McCartney was not there, one of her sons would be present. If this exercise happened during the day at a time when Mrs. McCartney or one of her sons was not present, Ms. Hall would accept the funds from the cashier and hold it in a covered spot on her desk and pass it on to Mrs. McCartney upon return to the office. Now, Mrs. McCartney's role was that she was the manager of accounts department. She was office manager, the vice president of the respondent. She and one of her two sons, Darren McCartney or Carl McCartney, provided the cashiers with their opening float of cash and counted and collected their closing funds. Mrs. McCartney was responsible for fiscal cash deposits. She was responsible for closing cashes out at the end of the day. And she checked on the cash and checks to make sure they were balanced at the end of the day. In her estimation, she did not pay particular attention to the returns customers made. Whenever cashiers processed the return of previously purchased items in the store, any one of Keith, Desiree, Darren, or Carl McCartney had to sign the paperwork authorizing the return. Ms. Hall was not involved in this exercise. Neither Mr. McCartney nor Mrs. McCartney, who both regularly reviewed the sales return reports, noticed inflated sales returns, or detected the alleged fraud of the cashiers from those reports. Neither of them noticed the alleged fraud from the accountant's quarterly reports, which they received either or from the respondents' computerized records, to which they both had access. So Ms. Hall stated that upon return to her work on April 3rd, and when she observed that the cashiers who used to work there were no longer there, she did not remark about it. Ms. McCartney met with Ms. Hall in the day and explained to her what occurred with the cashiers. Sorry, that was Mr. McCartney. He gave her the amounts the respondents believed that they had misappropriated. Ms. Hall indicated she wondered why they did what they did with the money. Mr. McCartney asked her how she could let the incident with the cashiers happen. Ms. Hall responded that she did not know anything about it. He retorted that she was there the whole time, so she should have known something was going on. Mr. McCartney put no documents about the incidents or the alleged misappropriation to Mrs. Hall and gave her no details of the date and times when the alleged misappropriation happened. Mrs. McCartney also mentioned the incident to Mrs. Hall on April 3rd. Mrs. Hall's response to Mrs. McCartney was that she did not believe it. At the end of the workday on April 4th, Mrs. McCartney gave Mrs. Hall a letter affecting her summary dismissal. The letter stated that the termination was due to recent fraudulent offenses of persons under her supervision, and that the respondent found her to be grossly negligent in performing her duty of oversight of the cashiers and in fundamental breach of a contract of employment. Mrs. Hall was the respondent's longest-serving employee. Mr. McCartney did not have any issues with Ms. Hall over her tenure and never had any reason to question her integrity. Mrs. McCartney accepted she had no evidence Ms. Hall ever produced any fraudulent document or ever made an untrue statement. So Mrs. Hall argues that her summary dismissal was wrong because she knew nothing about the alleged incidents of fraud or stealing. Her duties did not include the obligation to observe or oversee the cashiers in their daily cashing. The duty to oversee the cashiers in their daily cashing routine was held by the manager of accounts, which is Mrs. McCartney. And there was no reasonable investigation conducted by the respondent which lawfully could have supported an honest and reasonable belief that she was grossly negligent and as such justifiably dismissed. The respondents answers that Mrs. Hall, if not involved in the theft, was grossly negligent of or abandoned her responsibilities, as she ought to have detected the alleged fraud on the grounds that It was her duty as account supervisor to supervise the cashiers as her direct subordinates. She was at work and in her office when the misappropriation of funds occurred and could have seen the wrongdoing of the cashiers from her office. And thirdly, Mrs. Hall's behavior was suspicious in that she said nothing about the fact that the cashiers were missing when she came to work on April 3rd, in which Ms. Hall remarked that she wondered what they did with all that money. And then Ms. Hall, and their claim is also that Ms. Hall had a close relationship with the cashiers in which she worked closely, and she was close friends with them, and she traveled with the cashiers more than once on holiday weekends. So the summary dismissal, if it's not in compliance with section 31, 32, and 33 of the Employment Act. Common for adequate notice or justification on the basis the employee's conduct had undermined the employer's trust and confidence to the degree which releases the employer from the contractual obligations to the employer. In this case, the applicant had based her claim upon the Employment Act. The Act rests the burden upon the employer. In particular, sections 33 to 34. Went on to what 31 to 33 speaks about in the Employment Act, and I'll just go quickly over that. 31 says an employee may summarily dismiss an employee without pay or notice when the employee has committed a fundamental breach of his contract of employment or has acted in a manner repugnant to the fundamental interests of the employer. 32 says, subject to provisions in the relevant contract for employment, misconduct which constitutes a fundamental breach of the contract of employment or may be repugnant to the fundamental interests of an employee shall include but not limited to, and they list a few like theft, fraud offenses, dishonesty, gross negligence, etc. An employer shall prove for the purpose of any proceedings before the tribunal that he honestly and reasonably believed on a balance of probability that the employee had committed the misconduct in question at the time of the dismissal. So the tribunal must therefore determine whether the respondent has proven that it held an honest and reasonable belief at the time of Mrs. Hall's dismissal. It was more probable than not. She was grossly negligent in the performance of her duties as account supervisor. That belief of the employee must have resulted from a reasonable investigation of the alleged misconduct unless an investigation was not warranted. So going on, Ms. Hall also testified that Ms. Hall's grounds in which she is saying that, she should have not been dismissed. She stated that she did not supervise the cashiers in their cashing functions, and that the cashiers were supervised in cashing and handling the cash by Mrs. McCartney, who also did their performance appraisal. But the respondent from Mr. McCartney's evidence was that Ms. Hall had always worked within the accounts department, and she was a direct supervisor and trainer of the cashier. But he was uncertain when questioned during the trial as to some of the actual duties. As he explained, he did not work in that area. So the tribunal is satisfied that these responsibilities were a part of Mrs. Hall's accounts receivable job and were not relevant to overseeing cashiers while they were cashing. So Mrs. Hall also said in her explanation, Mr. McCartney was asked whether Ms. Hall had to reconcile customers' accounts, and Mrs. McCartney had explained that she was in charge of and supervised whichever cashier was working with her on that day to make calls to various delinquent customers concerning their accounts, letting them know and finding out what we can do, what we can expect as a payment. And then Ms. McCartney also went on to explain the reporting duty, indicated that she would give them a sheet as to who they would call, and they would report to her as who they call and what the customer had said. The tribunal had indicated that there was some treatment in the trial of the issue of whether Ms. Hall had a duty to train cashiers in cash-in transactions. But based on the evidence, the tribunal is saying that they're not persuaded that Mrs. Hall trained any of the cashiers who were dismissed in how to perform cash-in duties. And they found that the respondents desire that Ms. Hall trains cashiers in customer service and receivables collection had no relevant connection to the alleged duty to watch over the cashiers for the purpose of detecting wrongdoing as they performed their cashing duties. Reasonably, in order for Mrs. Hall to have caught wrongdoings of the cashiers during the proper performance of her duties, her responsibility would have to involve physical observation of their activities when they're working at their stations. So looking through the evidence, the tribunal could not find substantiation for the claim that Mrs. Hall had duties, the proper performance of which would or should have led to the discovery of any alleged misappropriation by the cashiers. So what they're basically saying is that based on Mrs. Hall's duties, she wouldn't have oversight. It also stated that where Ms. Hall was stationed, because it said that she was in an office area, she could not see all of the activities of the cashiers because where she was sitting. So in order for her to actually see that they were doing any fraud or anything at that time, she would have to actually be in that same area as the cashier, where the cash drops or whatever was being made. And like I said, the tribunal is saying that it's not satisfied that Mrs. Hall had a duty to oversee the cash in their daily cash-in functions. But even if Ms. Hall had a duty to oversee the cashiers and their daily cash-in functions, certain conditions of the respondents making would have hindered her ability to reasonably perform the functions with any level of efficiency. And then it said, like I was indicating, the place where she was stationed, she couldn't properly see the cashiers. And then her claim is also that certain duties were the duties of Mrs. McCartney. Based on the information that they had provided, the court found that, where is it? Okay, so the tribunal finds that the respondent has not discharged its burden to prove its honesty and reasonably believed on a balance of probability at the time of the applicant's dismissal that she committed gross negligence or knew of the fraud or misappropriation of funds of the cashiers as alleged. Neither has the respondent proven it conducted a reasonable investigation sufficient to find such honest and reasonable belief. Since Ms. Hall was dismissed by the respondent without reasonable justification and without being paid the statutory notice prescribed under Section 29 of the Employment Act, the tribunal finds that her summary dismissal was wrong. So in the end, Mrs. Hall was awarded 4 weeks pay for notice of pay for 4 weeks. She got a basic pay at 48 weeks, and the total that she was awarded was $33,020.
Mm-hmm. And you notice the tribunal went through and it spoke about the investigation
Yes.
in paragraph 35.
Mhm.
It said, let's go ahead if you want to read it so they could see.
Where's that in Section 35?
5.
Okay, okay. Okay, Section 33, honest and reasonable belief is not the same as a strong hunch, a gut feeling, or mere suspicion without support. Such belief must be based on a reasonable inquiry into whether the employee committed the impunged misconduct. A clear exposition of the required investigation an employer must pursue is found in the Court of Appeals judgment in Island Hotel Company Limited versus Shakira Isaac Sawyer. In that judgment, Longley P. distilled discussions of the characteristics of a reasonable investigation and the authorities to follow. So it says, what then is a reasonable investigation? Authorities seem clear. What one gleans from this is that the investigation must enable the employer to ascertain the true facts upon which it can make an informed decision to ground or support an honest belief on reasonable grounds that the employee committed the act of misconduct. It must be within reason, full, and fair. That would normally involve where it is considered necessary an account of the incident from many eyewitnesses or persons in the know as possible. Yet, at the same time, giving the employee an opportunity to be heard and to respond to the gathered information and complaint. When I read this, just based on their reasons, I went right to the back to see what the tribunal decision was, because based on what they were saying, I could see that she was dismissed wrongfully. You know, you're giving her an assignment to do, and because she's the supervisor, you're saying that, you know, she was negligent in which she did not discover that these cashiers were stealing the funds when she, first of all, couldn't see. And then they also based on that on assumption that because she used to travel with them during holidays, they were friends, and she would know about this scheme going on. But they didn't provide any like facts to substantiate why, you know, all these claims. Because based on what Ms. Hall was saying, you know, she was required to do this, she was required to do this. However, either Mrs. McCartney or her sons was responsible for these cash drops. And then they had the report where they could have seen if fraud was going on. They didn't pick it up. So they were putting, you know, that on her, that she should have known.
Yeah. And then in paragraph 25, when they say she had no written job description,
Correct.
employment or other document given by Battery and Tire, that her responsibilities. So
Right.
now that see that employees stole, they want to come up and put all of this on her, and they did not follow just the simple employment protocol.
Yeah, yeah,
But simply because they just didn't want to pay. Someone had to fall. And they
yeah. But, and then like, Mr. McCartney, when they asked him about her duties, he wasn't sure either.
No.
So someone had to take the blame for, you know, their, and I guess that is, you know, something they can learn from.
I hope that they did
Yeah.
and put things in place, because even like this is a small company. I mean, it's not huge, but these people still don't see the importance of having an HR manager.
Yeah.
Yeah.
And they also had the cashiers as witnesses also for her.
Yeah. So this is another one with, but you could call it a grievance procedure because you had to go through the whole investigation.
Yeah.
They could have seen they were negligent in this whole thing.
Yeah.
That wasn't fair to her.
Yeah.
Not fair. All right. So we got one down. Who's going next? That's Erica Hall.
Okay, I think I'm next for PPL, right? Is it?
Yeah, go ahead.
Okay. This was long. Very long.
Didn't fall asleep, right?
Huh?
Did you fall asleep? No.
No, I didn't, but oh man, it was just so many bits and pieces, so. Yeah, but I'm gonna try my best. So
Okay.
this is the Court of Appeal between Bahamas Electricity Corporation and Bahamas Power and Light Company Limited, the appellants, and Sherry Jennifer Brown, the respondent. Industrial Tribunal Appeal Appeal, Employment Law, Unfair Dismissal, Damages, Right to Mitigate. The respondent, Ms. Brown, was employed as a cashier for the appellant, Bahamas Power and Light Company. She was terminated after working there for 24 years and thus filed an originating application alleging that her contract of employment was unfairly terminated and she wishes to be reinstated. The appellant's defense was that Ms. Brown was justifiably dismissed for gross misconduct. The dispute was referred to the tribunal, and the judge ruled in favor of Ms. Brown and said she was entitled to damages in the sum of $6,067.80. The appellant has appealed the decision of the judge on the grounds that the vice president was misdirected in concluding that an alleged failure to allow an employee to mitigate in a case where there is overwhelming evidence of misconduct could be sufficient basis for a finding of unfair dismissal in the context of Section 34 of the Employment Act. The appeal was allowed. The award made by the vice president was put aside. Then we have, we're going through the background of the case. The judgment delivered by the Honorable Mr. Justice Milton Evans. This is an appeal by the appellants against the decision of Her Honor Miss Simone Fitzcharles, Vice President of the Industrial Tribunal, whereby she found that the respondent has made out of her claim of unfair dismissal and was entitled to damages in the amount of $6,067.80. So Ms. Brown worked at BPL for 24 years. She was a cashier stationed at an office, cashier's cage, shared by 3 workers from BPL and 1 worker from the National Insurance Board. The cashier's cage was situated in a room in the post office building on East Hill Street. She was a member of the Bahamas Electrical Workers Union and a part of the bargaining unit. The industrial agreement between Bahamas Electricity Corporation and the union, which expired on April 30th, 2018, governed the employment of the applicant prior to her dismissal. The incidents that led to Ms. Brown's dismissal was caught on camera installed by BPL, and they were stationed inside and outside of the cashier's cage. The footage on the camera shows a male entering and remaining and interacting with Ms. Brown, then leaving the cashier's cage. The video captured activities on 4 separate days: April 14th, April 22nd, April 25th, and April 26th. The male was identified as Kim Ferguson, who was a post office employee. Evidence showed that Mr. Ferguson, on some occasions, was given access by Ms. Brown to enter the cashier's cage and by others working in the cashier's cage who would leave the entry-exit door unlocked. The video footage also showed that in addition to Mr. Ferguson having access to the cashier's cage, Mr. Ferguson and Ms. Brown engaged in activities of an intimate nature with each other while in the presence of the other employees. This footage was showed to the tribunal during the trial. The respondent produced a written report from the security manager, Mr. Stephen Strawn, who conducted investigations of the activities in the cashier's cage on the 4 days that was stated. In the report, Mr. Strawn observed that Mr. Ferguson seemed to have no substantial business or business reason, but personal visits to see Ms. Sherry Brown. All of the visits involved inappropriate behavior with sexual connotations between Ms. Brown and Mr. Ferguson. Ms. Brown, a veteran employee, did nothing to prevent or dissuade the unauthorized entry or presence of Mr. Ferguson in the corporation restricted cash intake area. Actually, her behavior encouraged quite the opposite and exposed the cage during its operation. BPL's complaint against Ms. Brown was gross misconduct comprised of the two activities. She breached BPL's restricted access policies to the cashier's cage by allowing an unauthorized person access to the restricted area during the allowing an unauthorized person access to the restricted area. And during this unauthorized access, Ms. Brown engaged in conduct of lewd or sexual nature with the person who was not authorized to be there. At the cross-examination, Ms. Brown admitted that she did the acts for which she was dismissed. Even so, the recordings of the video was confirmation that she did do it. So the Vice President set out in her decision a summary of the evidence before her. These are the evidence pretty much in the, I guess, the negotiation of the appeal, I think. So Ms. Brown knew about the investigations conducted by BPL into her activities, but she was not made aware of the results of the investigation. The issue of her role at the corporation and the circumstances surrounding the unauthorized entry of Mr. Ferguson was put to her by Mr. Strawn, who also asked her what she and Mr. Ferguson did after he came into the cashier's cage. She was asked in her meetings with BPL managers if she had anything to say, which she declined. But on May 4th, she said that she did not understand why she was being suspended when all she did was just hug Mr. Ferguson. She was told by Ms. Johnson at the time that she, Ms. Brown, know that she did more than hug Mr. Ferguson based on the footage. Ms. Brown did not respond. She then told them the next day that she remembered that she lifted her dress. She sought legal advice from Jennifer Isaacs Dotson. She did commit the conduct for which she was summarily dismissed. As a longstanding employee at BPL, she is familiar with the restriction on access policy as set out in the customer service memo and the cash handling policy and procedures manual. Mr. Ferguson was not authorized to enter the cashier's cage, and she had a responsibility in determining who can access the area. Her conduct with Mr. Ferguson was unprofessional and fell below the standard of conduct required of her as a longstanding employee. She had, during the investigation, the benefit of union representation and legal advice, and she was given a moment to consider her position before continuing in an interview with Mr. Strawn. Before she was dismissed, she was informed by the union representative that BPL decided to dismiss her, but the representative was trying to get resignation instead. She acted upon advice from her lawyers before the meeting in which she was dismissed. The decision to dismiss was made upon the basis of the results of the investigation, which were communicated to the executive level of BPL by a written report. Ms. Johnson did not get a copy of the report. The Assistant General Manager, Ms. Marissa Smith, gave Ms. Johnson the instructions to carry out the dismissal. Prior to her suspension, Ms. Brown was told that an investigation was being conducted in gross misconduct. She was not told what constituted the gross misconduct. When the suspension was extended, Ms. Brown was not told at the time of any findings of the investigation. She was told the investigation is not complete, so they have to continue with it. Ms. Johnson said she did not give Ms. Brown the findings of the investigation, such as the reports from the co-work, Ms. Johnson says she did not give Ms. Brown the findings of the investigations, which were the reports from the co-workers and the video footage. No report was prepared by the post office worker, Mr. Ferguson. Even though Ms. Brown did not get written reports, she was questioned based on what was in the reports and given a chance to respond. She was asked questions about the investigation and the nature of the investigations in the meetings she had with BPL. Mr. Strawn said that his investigations were solely based on the video footage. And he found that other persons who were not authorized to be in the cashier's cage had access, but it was not given by Ms. Brown. Sorry, gotta go over. Okay, and so continuing on, the findings basically by the vice president pretty much ruled the same, but I'll just go through a few of them. The parties put in issue the exact character of the activities between Ms. Brown and Mr. Ferguson. While Ms. Brown in her arguments repeatedly stated that she simply displayed romantic behavior, BPL in its evidence argued that indeed Ms. Brown's behavior was lewd and inappropriate with sexual connotations. The tribunal has a duty to consider the substantial merits in any unfair dismissal claim. The precise character of the acts committed is a factor to be weighed with others in the balance. Basically, the footage showed that Ms. Brown on 2 occasions opened the cage door for Mr. Ferguson, and on 2 occasions escorted him into the restricted area. On 3 occasions, Mr. Ferguson accessed the cashier's cage as the door was either left open or unlocked by another worker. So based on the camera footage, Mr. Ferguson's main reason for visiting the cage was to find Ms. Brown for the purpose of chatting, groping, kissing, touching intimate parts of her body. And Ms. Brown also exposed private areas of her body. Ms. Brown's witness statement mentioned that she did perform similar acts. In BPL's case, there was no evidence of any prior history or tolerance in the workplace of the behavior engaged in by Ms. Brown. The personal behavior and deportment of Ms. Brown, her conduct on the job, was called into question by her activities. BPL did not have as one of its major offenses, which could attract immediate dismissal, a specific category of indecency or gross indecency as contained in the Employment Act. But this was not necessary. For in many employment cases where indecorum with sexual overtones in is the employee's offense, gross misconduct is often the reason for dismissal. Taken also on its own, the granting of unauthorized access of prohibited persons into the cashier's cage amounted to a violation of BPL's policies or procedures or failure to observe or enforce safety rules or operating procedures, which are minor offenses not punishable by dismissal of the industrial agreement. This may be why Ms. Brown's colleagues were not dismissed for their respective roles in permitting the unauthorized entry and remaining of persons in the cashier's cage. However, in Ms. Brown's case, there was more involved. The entire conduct was a combination of giving a person who was not a BPL employee unauthorized access in a restricted area for the apparent purpose of engaging in unacceptable behavior with sexual overtones on several occasions. This was considered by BPL to be gross misconduct, punishable by summary dismissal. Okay, and then the vice president found that notwithstanding her findings relative to the nature of the conduct of the respondents, as this was a claim of unfair dismissal, she was required to have regard to the procedure established for discipline and the extent to which it was followed. This part I wasn't too clear on. So Ms. Archer, if you can help me a little bit.
Go ahead.
The industrial agreement set out a detailed procedure in relation to disciplinary procedures and termination of employment. It included a right to appeal a termination of employment in the event an employee was disgruntled. It also in clause 17 set out a detailed 5-stage process which employees could engage to resolve their unemployment grievances, including a suspension or dismissal. So upon consideration of the provisions, the tribunal finds that the procedure set out in the industrial agreement on the issues of discipline, grievance handling, termination of employment, and appeals was a fair one for both stakeholders, the employer and the employee.
Mhm.
So that part I didn't get.
Okay, so remember they said at the very beginning that
Mhm.
time that she was employed, she was still under the industrial agreement,
Okay,
right? So as a part of the industrial agreement, they would have a grievance procedures within that agreement.
oh, okay,
And you have to
okay.
pass.
Oh, so, okay, as a part of the industry, okay, okay.
Mhm. So
So
she
they
was
would have,
the part
so
of
she
the,
was within those grounds is what I was confused about.
no, yeah, they're
No.
saying follow the steps that are set out in the actual agreement. So
Mm,
So you,
okay,
whenever an employee is disgruntled, you go through the grievance process. And
oh,
then
okay,
one has that process already set out. It's not separate and apart. Once you unionize, it is a part of that union agreement.
oh, okay. Oh, okay, okay. Okay. So okay, I got it. So in her decision, the learned vice president in paragraphs 30 and 48 dealt extensively with transpired during the investigation. So basically she's saying once the investigation was completed, Ms. Brown was informed about the findings, and that she was guilty pretty much of gross misconduct. And then she had a clear idea of the repercussions of this gross misconduct. The evidence that was put before her, and why BPL decided to dismiss her. She also was given an opportunity to seek legal counsel after being told. Coming down to the final analysis, Ms. Brown, having heard BPL's, if she has given if she had been given, oh, this is the part I need your help with too, Ms. Archer. So coming down to the final analysis, Ms. Brown was not given a chance to say why she should not be dismissed before the decision was made. If she had been given that chance, there is based on an assessment of the case she presented a single point in mitigation she could have advanced. That part I wasn't clear on. So is this a part of the decision?
Which paragraph? You paragraph 9, subparagraph what?
I'm on page subparagraph by 64. On
Okay,
page
coming down,
15.
this I see you. Ms.
Mhm.
Brown was the chance to say why she should not be dismissed before the
Right.
If she'd been given that chance, there is based on assessment of the case she presented a single point in mitigation she could have advanced. Oh, I see. So this
Mhm.
when they came down to making that final decision,
Right.
they didn't give her the opportunity before they gave her that termination letter for her to state her case that she had been working with BPL for over 24 years.
So they didn't give her a chance like to argue that then.
Yes.
Mm,
But they're saying that they doubt the BPL would have, I guess, given that much weight.
right, right.
It's clear, and they said
Yes.
because she had worked there so long, is why they thought that her
Right.
act,
Yes, she should have known better. That
right,
she should have known better. Right.
right. If she argued, that wasn't going to help her.
Look, right. So it wasn't gonna have no weight, right? Okay.
Mhm.
Okay. But it says here, yet on balance, I cannot say that her plea would have failed.
You don't know,
Okay.
yeah. But it was because
Okay.
it was. So now she's making, now that's what happened at the tribunal. So this is now the appeal,
Mm-hmm.
and they've lodged all these different grounds.
Right.
7, 8, 9, 10, 11, 12, 13.
Right. But
Killing a
it's
lot.
all, yeah, and it's all based on the recordings, the video recordings and everything, all the evidence.
Mhm.
Evidence given by Mr. Strawn, the co-workers, and the video. Now 7, the part, I couldn't figure out the calculating part, because it wanted to seem as if they were saying that she should have gotten more, and even with the money, so this was on, and number 7.
Okay. In number 7, they
But
said
not
that
the calculating.
they said the learned president erred in law and in fact and misdirected herself in finding that should she award the respondent
Right.
the
The
$6,000,
$6,067.
no,
Mhm.
yeah, in determining the amount that a full basic award would amount to in the respondent's case, the learned VP failed to apply the proper calculations. Rather, the VP ought properly to have ascertained the respondent's weekly salary by dividing daily salary by 52, which would have yielded the weekly sum of 777.92. And thereafter, the VP should have multiplied 560 this weekly salary by 3 weeks, which would have yielded the sum of 233.77, which should have multiplied by the number of completed years worked. This methodology would have been based upon 72 weeks pay, which is less than 18 months statutory maximum pay, as the latter is comprised of 78 weeks. So had the learned judge performed the calculation in the manner, she would have ascertained a compensation for the basic award in the sum of 56,000 compared to 60,000
Oh, okay, okay.
at the way in which it was calculated. But at the end, you saw the judge, they only allowed the appeal on grounds 4, 5, and 6.
5 and 6, yes, yes. I get that. Yes. Yes.
So they
So,
calculate the material.
yes, okay, okay. So as a part of the discussion, I am satisfied that there is no merit in grounds 1 and 3 of the notice of appeal. As noted by the learned vice president, the respondent elected to pursue a claim for unfair dismissal, as such as her remit was thus limited to that claim only. The vice president's position was based on decisions from this court by which she is bound. These cases make it clear that it is an error for the tribunal to embark on a claim not referred by the minister or listed in the originating application. It is beyond dispute. Sorry, no. It is important to know, sorry, I lost my thing, I'm here. Okay, what is readily evident from the facts of the 2 cases relied on by the vice president is that the employers in these cases failed to follow the disciplinary procedures which were in place. It was that failure which deprived the employees in these 2 cases of the opportunity to present items of mitigation. In the present case, as found by the vice president, the procedure put in place was fair and the disciplinary proceedings were conducted fairly. The respondent was fully appraised of the allegations against her and was given the opportunity to respond to the same with the assistance of her union representative, as well as her attorney. Did the applicant have a clear idea of the repercussions of being found culpable of gross misconduct? Yes, adequately so. Although the industrial agreement stated plainly that summary dismissal could be a result of gross misconduct, so could suspension of up to 20 days. However, Ms. Brown was directed to clause 16.5 in letters from BPL, which clearly set out the two possible repercussions of gross misconduct. Further, she was able to take legal advice about termination of her employment before she entered the final meeting with BPL. The evidence against the respondent was compelling, and it is understandable why she did not pursue a claim for wrongful dismissal. So it would have been a baseless claim with no chance of success. In my view, faced with the evidence of the video recording, it was open to the respondent to accept responsibility for her actions and throw herself on the mercy of her employers. Instead, she continued to dispute incontrovertible facts. She had every opportunity to make representation as to why she should not be terminated, but failed to avail herself of the same. Lastly, Ms. Brown argues in mitigation that she is a longstanding employee. I think this was the part where there was her continuous claim, yeah. So this is amongst the other factors submitted in mitigation. The only one the tribunal believes is a point which is to be considered a mitigating factor. However, usually in unfair dismissal cases, there are other legitimate factors such as history of stellar performance, promotions, substantial and early honesty in the investigation, or an apology for the wrongdoings, which was taken together with long-term employment converge in a convincing case that, if heard by the employer, may have reduced the sanction of dismissal. Having heard BPL's argument and presentation, I have some doubt that the employer would have much been convinced by that point in mitigation. BPL felt that Ms. Brown's status as a long-standing employee made her conduct more arrogant, as BPL expected someone of her years of experience not to breach its trust and confidence in this matter. As the respondent submitted, yet on balance, I cannot say her plea would have failed. And so basically, I think in everything just kind of pointed towards her guilty. She couldn't get out of that.
No.
Yeah, she couldn't get out of that.
Have thrown herself to the mercy of the court.
Yeah, like I said, she could have.
Everything was on the videotape. Her actions from the videotape were not actions of just hugging anybody.
No.
She did body gyrations and all of that.
Yeah. And at one point, it said she kind of opened her legs and lifted her dress and exposed her private parts. So, yeah.
I just had a question. I wasn't sure if I missed it. Apologies if I did. So was she aware when she gave that statement that everyone had the tape?
Of course, tape in court.
Yeah.
So she just
It was
lied
played
and
in
thought
court.
that her word would be believed. Okay, I just wasn't clear on that point. I thought I missed something.
Yeah, the video was
Okay.
showed. The video was showed in court.
Right, but I'm wondering if she's still, I mean, was that before?
So they said that one of her arguments was that she never received reports of the investigation. I know she knew that there was an investigation. She knew that there were cameras there as well. But she never received reports of the investigation. That's what she argued also.
But like the judge said, she said she should have threw herself at the mercy of
Mercy seat.
So
Yeah.
I mean, what else can you say?
Yeah.
I just didn't understand how you could lie in the face of evidence. So I just wondered if I missed something.
No.
Yeah. Okay.
I don't know what she was thinking, and to go to this far all the way to the Court of Appeal, and you have tapes.
Did you just say embarrassing? It's crazy.
Yes.
But it said that she had representation from her union as well.
Yes, she did.
So she obviously was advised and coerced.
Mm-hmm.
And they felt as if she could have won something.
Say, because it say here,
Wow.
Mr. Ferguson, he visited the cage for the purpose of chatting closely,
Right.
groping,
Groping, kissing,
intimate parts of the body.
body with Miss Brown.
Yes,
Yes,
what she think was going to happen and all that's
I don't
on.
know. And on four different occasions, you could see if it was one time.
Being there.
Yeah. Yeah, I don't know how she thought she could get out of that, but
No,
yeah,
that's what she did.
yeah.
Mm-hmm. There's no way she could have mitigated anything. with that.
No, no, there was
She
no
was-
way she could have mitigated.
No, she was finished. Hey, so that's another it's another procedure to see how an employer must make sure they follow all the steps of the procedure. And
Mm.
when a union agreement, you have to make sure you follow the steps in the union agreement that pertains to grievances.
Okay,
Step. You have to follow the steps.
okay.
Yeah. Who's next? That was a good one. Don't worry, grievance procedures are on the exam.
Oh, boy.
Okay, I'll go next,
Okay.
with one of mine. It's Bahamas Power and Light Company Limited and Don Smith. So this case went before the Industrial Tribunal for appeal based on unfair dismissal due to duress. So the respondent was employed as an assistant plan operator with the appellant from 2004 until 2017. He suffered a seizure, which severely affected his performance on the job. And so he was given a disability retirement package in 2017. Mr. Smith signed a deed of release and accepted the package that was offered. But in April 2018, he filed an originating application at the Industrial Tribunal alleging that he had been unfairly dismissed. In 2019, the vice president of the tribunal held that the respondent was in fact under duress when he accepted the disability package and had been unfairly dismissed. Mr. Smith appealed the decision based on the grounds that the vice president, sorry, not Mr. Smith, BPL, the appellant in this case, appealed on the grounds that the vice president erred on the finding of unfair dismissal in our application of the principles of duress. So the appeal was allowed and the judgment of the vice president was set aside and funds ordered to be paid by the judgment in excess of the settlement between the parties fell away. So there's a definition of duress that is referred to. And it says, referring to threats, violence, constraints, or other actions used to coerce someone into doing something against their will or better judgment. And it says, it's clear that the evidence of duress did not rise to this standard, and the VP did not purport to find that it did. The VP did not seek to fit the facts of this case into the legal definition of economic duress, relying on Hennessy's case, where properly understood, the ratio of that case, and I had to look that word up again, Ms. Archer, of that case is that in order to succeed on a claim of duress, it must be shown that the payment made or the contract entered into was an involuntary act. It is clear that even on the evidence of the respondent, it cannot be said that his agreement to the settlement was an involuntary act. The evidence from both sides was consistent in confirming that the respondent sought legal advice before making his decision to accept the settlement agreement. The VP's findings of unfair dismissal was based on her view that the appellant did not do enough to accommodate the respondent in remaining employed. Unfortunately, in her findings, the VP does not say why what was done was inadequate, nor did she identify additional steps that could have been taken to accommodate the respondent. In the circumstances, I have found, sorry, in the circumstances as I have found them, this is Justice Evans.
Mhm.
I am of the firm view that the settlement arrived between the appellant and the respondent was effective and therefore binding on both parties. And by virtue of the compromise, he had agreed to forego any further claims. So then to give a bit of background, well, it says initially the judgment. This is an appeal by the appellant. I think we already covered that part. It's unfair dismissal based on the fact that he felt that he was under duress when he signed the release. And then it gave some additional background in terms of his duties. He was an operator or shift foreman who operated all boilers, gas turbines, etc., diesel generators. So his job was, along the lines of where he needed to really be physical and active. So about after 5 years on the job, he began experiencing headaches and nosebleeds. And 6 months later, after that, he suffered a grand mal seizure. And he was hospitalized and treated in the emergency room. When he returned to work, he was still not fully recovered, and he began to suffer adverse effects. His condition did not improve. He had additional treatment and still did not improve. And so BPL relocated him to a desk job, but for whatever reason, that did not work out. So then fast forward to 2017, they presented him with the retirement package. The AGM, who's HR and training at BPL, Mr. Smith, along with Chiquita Johnson, who was the manager of compensation and benefits. They prepared and presented him with this retirement letter. So after the meeting with Mrs. Smith and the two managers, he signed the deed of release and accepted the funds. However, a year later, in 2018, he filed this claim, citing unfair dismissal. So in the evidence before the tribunal, the respondent acknowledged that he signed the deed of release and accepted the money and spent some of the money. However, he stated that he felt that he had no other choice but to sign the release. He claimed that he did not get advice from the union, but he did receive advice from his lawyer, who he found, however, he still felt like not accepting the settlement was not an option for him. And the appellant, BPL, went so far as to tell him that this is his final offer. So the findings from the tribunal, after hearing the evidence from the counsel, the VP ruled that the respondent had in fact been unfairly dismissed and said that it's apparent that the decision was based on two specific things. First, because the appellant, the VP ruled that the applicant testified that he was under duress at the time of the release and cited numerous authorities that supported this as a basis. And the second finding was that the respondent gave an indication of the attempts sorry, I skipped a part. The tribunal was therefore of the opinion that the applicant was in fact under duress when he signed that release. And the second finding was that the respondent gave some indication of the attempts that were made to otherwise accommodate the applicant, Mr. Smith. The question that the tribunal had was whether or not BPL made sufficient attempts to accommodate him in other roles. So there was a determination based on the ruling in Mr. Smith's favor that he was unfairly dismissed. And so he was awarded the sum of $57,590 and change, in addition to payment of $689 per month for about totaling $16,000. This is what he was offered. But the tribunal ruled that he would get this $689 for the rest of his life, rather than the 2 years that BPL had, agreed to him with previously. So on appeal, it was determined that the VP erred in law by completely ignoring common law principles, in particular the law of contract, by finding that the respondent was entitled to a sum above and beyond the payout provided by clause 19 of the industrial agreement between BEC and Bahamas Electrical Workers Union. The VP erred in law by making a finding of unfair dismissal and not giving due regard to section 77(2) of the Employment Act, which provides that this act shall not apply to any industrial agreement registered with the tribunal. Thirdly, the VP erred in law by failing to properly apply section 35 of the Employment Act, in particular, whether the dismissal of the employee was fair or unfair shall be determined in accordance with the substantial merits of the case. 4, the learned VP erred in law in her application and in the reliance that she placed in the principles laid out in the case of Hennessy. In particular, when she considered the issue of duress, it ignores and makes no comment or reference to considerations set out in Hennessy with regard to economic, which says that economic duress can only provide a basis for avoiding a contract if there is no real alternative. Ground 5, the VP erred in law by applying the wrong test as it relates to the burden of proof, as she wrongly required the appellant to prove that the respondent was disabled and unfit, whereas the respondent never led any credible evidence that he was fit to work and not in fact disabled. Ground 6. So essentially, she erred in all kinds of ways. Ground 6, she erred in law by wrongly applying sections 6 and 7 of the Employment Act. In particular, no employer shall discriminate against an employee by dismissing solely because of his or her race. Section 6 shall apply mutatis mutandis to disabled employees unless the employer can show the disabled person cannot be accommodated without undue hardship. Ground 7, the learned Vice President erred in law by wholly failing to take into account the requirements imposed on both employer and employee by Section 4 of the Health and Safety at Work Act 2002, which says it shall be the duty of every employer to ensure, so far as is reasonably practicable, the health, safety, and welfare at work of all of its employees. Ground 8, the learned VP erred in law by failing to consider the cornerstone of employment law, that there is an obligation of trust and confidence, which the respondent breached. So ground 9, she erred again in law in her failing to properly apply or by ignoring Section 46 of the Employment Act, in particular, where the tribunal finds that the dismissal was to an extent caused or contributed to by an action of the complainant. Ground 10, the VP erred in law by failing to apply the proper principle of contract law, offer and acceptance. The respondent freely accepted the disability package that was offered to him by the appellant in full and final settlement of all obligations owed to him. And ground 11, any other grounds that the court may deem just and equitable. So they found a lot to disagree with the VP of the tribunal about.
But look at the route in which the court is taking. The judge is going to say now that despite all of these different grounds that they're appealing, they entered into a contract.
Yes. Yeah. Exactly. So in discussion, they're saying notwithstanding the multiplicity of grounds filed by the appellant, there are two salient questions to be answered. First, it must be decided whether the settlement agreement signed between the parties was effective and therefore binding, speaking to the contract. If it was, then that would be the end of the matter. If it was not effective and binding, then the second question becomes, was the termination of the respondent considered unfair in all the circumstances of the case. Let's see if I can sum any of this up. So it's not too long, so I'll just go through the rest. So in reviewing the matter, again, Justice Evans said, I remind myself of the terms of Section 64 of the Industrial Relations Act as follows. Subject to this act, any party to a matter before the tribunal is entitled as of right to appeal to the Court of Appeal. The tribunal had no jurisdiction in the matter, but it shall not be competent for the Court of Appeal to entertain such ground of appeal unless objection to the jurisdiction of the tribunal has been formally taken at some time during the progress of the matter before the making of the order or award. That the tribunal has exceeded its jurisdiction on the matter. So I think this is just saying where there, what gives them the right to overturn the tribunal.
Go, yes.
Okay.
Mm-hmm.
That the order or award has been obtained by fraud. And they have underlined, which D is, I guess, the point that they're basing it on, that any finding or decision of the tribunal in any matter is erroneous in point of law. So they highlighted that as the issue that's applicable in the case.
Mhm.
I mean, sorry, the point. Okay. So it said, it is ground 4 where the issue as to the validity of the settlement of agreement is raised. And I find it convenient to begin there. The respondent admits to signing the deed of release. And the final paragraph of that document says the following: I, Don Smith, the undersigned, rely solely upon my judgment and without influence by anyone in making this full and final settlement, I fully understand and voluntarily accept the terms of this release.
And he expect to get to do what?
Quite, I
After
mean,
sign-
crystal clear, right?
Yes.
Exactly. And then I was wondering a whole year later, so April 2017, this happened. I don't know if the process takes that long, but then April 2016, you're filing, the claim after
Mhm.
you already spent money, so I found that curious. The respondent makes no allegation that the appellant exerted any undue pressure on him, save to say to him that the offer which was being made was their final offer, which is what he said. He felt a sense of duress because they said this is their final offers, they being BPL.
Mm. But is that direct?
No, I mean, I don't think it's duress, personally.
No. If you didn't like the final offer, then he shouldn't have signed it.
You shouldn't have signed it. And then you go to your lawyer and you try to fight otherwise, or to
right,
the
right.
union. So the evidence from both sides was consistent in confirming that he sought legal advice before making his decision. It follows that there was really not much dispute as to the evidence which the VP had before her to determine whether there was duress. The question was whether those facts were sufficient to constitute duress in law. Then they go on to define again the definition of duress, which refers to threats, violence, constraints, other actions used to coerce someone into doing something against their will or better judgment. And then he says that it is clear that the evidence did not rise to this standard, and the VP did not purport to find that it did. The VP did not seek to fit the facts of this case into the legal definition of economic duress, although she purported to rely on Hennessy's case. In the circumstances, Justice Evans found them, Justice Evans found them, he's of the firm view that the settlement arrived at between the appellant and the respondent is effective and therefore binding on both parties. It would follow that even if the respondent was entitled to a greater benefit by virtue of the compromise, he agreed to forego any further claims. So in the event that I'm wrong in my view on the issue, he went further to consider whether the VP's findings of unfair dismissal could be upheld. He then states it's apparent that her finding was based on her view that the appellant did not do enough to accommodate the respondent in remaining employed by placing him, on another role within the company, which they did, but for whatever reason, they didn't say why, but they said it did not work out. So they did try to. She, however, states that in her view, they could have done more. This is the VP. Unfortunately, in her findings, the VP does not say why what was done was inadequate, nor did she identify the additional steps which they could have taken to accommodate the respondent in the circumstances of the case. As such, even if I were to find that the respondent was on good footing with the claim of duress, I could not uphold the VP's findings of unfair dismissal. I would therefore set aside the judgment of the VP, and thus any funds ordered to be paid by the judgment which exceeds the agreed in the settlement agreement between the party falls away.
Mhm.
So they overturned the tribunal's ruling, and the initial agreement would stand.
Dan, yes.
Yeah. So rather than getting his $700 odd for life, he got the 24 months and his lump sum.
Yeah.
Yeah. So I thought that was a pretty fair assessment of the case by the Court of Appeals. And I did think that the VP's position was rather subjective, because it is true, she didn't really base it upon anything substantive, that they could have done more, but without outlining what they could have done.
Yeah. But he shouldn't have signed it if he wasn't happy with it.
Agreed.
Yeah, he should not have signed it.
Yeah, and it's to me, again, he had advice from the lawyer. So what did your lawyer tell you? What did he recommend or suggest? So,
Mhm.
that
But he-
was interesting too. He still went
Yeah.
ahead and signed.
But he should not have signed it. If he didn't feel like it was adequate, he should have taken his chances.
Mhm.
So, by law, he would have gotten the statutory amount.
Yeah.
Yeah.
But I figure he see that lump sum, he'd see almost $60,000. He probably thought that was more than it was,
Mhm.
and then decided it went too fast a year later.
He probably,
Yeah,
he probably spent it.
I think so. Yeah. Okay.
But again, you all are beginning to see how you go through these procedures.
Mm-hmm.
It has to go through those steps. Otherwise, the industrial tribunal will not find in your favor.
So I had a question when I got to the end of it, Ms. Archer.
Mhm.
They have the three justices, right? Justice Evans, Isaacs, and Bethel, who preside in the Court of Appeals at once, right? And so they say, I agree, I also agree. So is it like 2 out of 3 and then the decision is taken, or do they have to all agree?
No, if one of them didn't agree, then you would have seen something that said the dissenting judgment. If
But I
love
mean,
then why?
but would 2 who agree, like, you know what I mean?
Yes,
Is it majority rule?
we'll go to majority, yes.
Okay. I just wondered. Okay.
Yeah,
Thanks.
good. All right, who's next? By the time you finish these, there's no way you cannot answer a question on the final exam. Not possible.
Hint, hint.
Yeah, hint. Not possible. Who's next? Frederick Ferguson.
Yes, Frederick Ferguson is me.
You, waiting on you. That's
Why?
good.
Why are you waiting on me?
That's
Okay.
on
Huh?
top of my pile. It's on the top of my pile, and I look at my list and I see Butler. Yes, go ahead.
Okay. So let's start. Frederick Ferguson. So Frederick Ferguson worked at Island Hotel Company since July 1980. He was promoted to the position of Director of Casino Cage Operations in December of 2008. Now, as director of casino cage operations, she is responsible for the cage where the gaming chips are kept and distributed. In June 2009, a shortage of chips were discovered, about 5,000 short. Now, this led to a full count of the inventory, which revealed that the inventory was short by 50,000 at the Cove and 10,000 at Sea Glass. The appellant Frederick Ferguson was summarily dismissed 2 months thereafter following an investigation and notice of unsatisfactory performance. Mr. Ferguson filed a dispute for wrongful dismissal, which was dismissed. He now appeals the tribunal decision. Okay, and this is the point where we are at. The tribunal appeal was allowed and ruled that the appellant is entitled to the monies he would have received under Section 29 of the Employment Act. The reason they go through the history of Mr. Ferguson's case so we can understand why they ruled that way. When they discovered the missing chips, the investigation ensued. It took 2 months. I don't understand why it took so long for them to complete this investigation. However, Mr. Ferguson was suspended for 1 day, and not because of misconduct, unsatisfactory work, or violation of any rule, but because of gross negligence. According to the notice that he was given, it said that Mr. Ferguson's primary duties as director of Casino Cage, he failed to exercise proper judgment and fiduciary responsibility regarding control procedures in the management of cage operations, which resulted in a loss to the company in the amount of $60,000. Now, after receiving the suspension, Mr. Ferguson was not asked to explain or give an account for any complaint being made against him. That's where they went wrong, one. Then the following day, he received another notice of unsatisfactory performance, which again listed his infraction as being gross negligence. And attached to this notice was the list of, or identifying the particulars surrounding that. And it read, cash management was negligent with regard to monitoring the inventory level of chips. Cash management was negligent with regards to enforcing the policies and procedures in effect. Cashiers and supervisors were negligent in the performance of their duties by not conducting a full count of the inventory. Now, if you notice, it kept referring to cash management. Nowhere in there does it specifically refer to Mr. Ferguson as being negligent or in any way committing these infractions. And so it's unclear why that Mr. Ferguson was dismissed when they're referring to cash management, when his senior vice president, who would have fallen under that category, was not in any way deemed negligent or given any discharge notice or anything of that nature. So that's where they erred again. Another, go ahead. Another factor too that I note was the fact that in each notice or report, it says that cash management was negligent. It refers to it as being negligent. However, the notice that he received said that his infraction was gross negligence. So there seems to be a disparity between the notices given and the actual infraction for which he was dismissed. So those particulars did not say that the appellant as director was grossly negligent in his performance as director. So the burden is on Island Hotel to actually prove that the director was grossly negligent in the performance of his duties, since they decided to summarily dismiss the appellant. Right?
Mm-hmm.
With me?
Yeah, me with you.
Okay. I'm trying to read. So it says an employer may summarily dismiss an employee without pay or notice when the employee has committed a fundamental breach of his contract of employment or has acted in a manner repugnant to the fundamental interests of the employer. Then it lists some of the items that are considered to be a breach of contract: theft, fraudulent offenses, dishonesty, gross insubordination, gross indecency, breach of confidentiality, gross negligence, incompetence, gross misconduct. In reading through the case, there's nowhere that Island Hotel was able to prove that Mr. Ferguson was grossly negligent in performance of his duty, and therefore they erred when they listed that as an infraction on the notice. Okay? We can continue from there. I'm trying to continue to read. I don't want to read all of this. Okay, and so another, after the investigation was conducted, it took 2 months. They interviewed all of the supervisors, cashiers, shift managers, casino security director, etc. The tribunal indicated that we do not agree that, or the Court of Appeal, we do not agree that the tribunal could have properly held that the evidence disclosed that after reasonable investigation, the respondent held an honest and reasonable belief that the appellant was guilty of gross negligence. In other words, essentially they just threw him under the bus. There was nothing that they could have proven to show that Mr. Ferguson was grossly negligent, that he in any way committed the infractions based on the investigation that they conducted. In addition, they did not give Mr. Ferguson an opportunity to even defend himself, to show or to prove why he was not negligent, in that they suspended him for 1 day, and then the next day they summarily dismissed him. So eventually, in the end, in summary, Mr. Ferguson ended up winning the case, and Island Hotel was proven to be incorrect or wrong in their judgment. That's it in a nutshell.
Yeah. Because even the investigation itself, they say couldn't be regarded as being reasonable.
No.
So
And of course, they did not follow the proper disciplinary procedures, because a part of that is that he is given an opportunity to defend himself and to say why, or provide his own, I guess, summary of the investigation and why is it that their actions or the summary dismissal was not correct. He was not given an opportunity even to defend what happened with the chips, that kind of thing. He was the director, so he wasn't directly even responsible for what happened on the floor. There are persons who, when you looked at the chain, he was almost at the top, and those persons were supervisors. The managers really were responsible. He just provided the executive oversight. So he was not even allowed to even present that argument, given the short notice that he got, when they dismissed him, when they suspended him, then dismissed him.
Yeah. So for those who, when you read the case, you look at paragraph 24, where the judge said the appellant was suspended for 1 day. The evidence does not disclose that any investigation took place during the day he was suspended.
Right.
He was terminated the following day and was never given any opportunity to answer any charges that the respondent may have had about his conduct. The fact is, suspension was a facade, and the decision to terminate was made before any suspension.
Right.
The decision to terminate was made after the investigation that took place following the incident and before the suspension. In our judgment, where an employer does not comply with its own disciplinary rules as to an investigation into misconduct, that investigation can hardly be regarded as reasonable.
Right.
And that's it. You have process and you do not follow the process, the court will rule against you.
Against you. But the investigation took 2 months. That is where I was a little, like, in during that 2 months, did they not, I know they were interviewing all of the persons who were involved. And they had indicated that he should have had some idea that he would be under scrutiny. However, I guess he did, in his defense, he didn't think that based on where he sat, that he would have been really involved in the deep investigation of the incident or even be considered for dismissal. Because I didn't understand, if it took 2 months, why during that 2 months he was not given that opportunity to speak?
Yeah. They just decided that he'll be the fall guy.
Yeah,
Mm-hmm.
because that's a lot. And then you wait 2 months, you do an investigation for 2 months, and then you suspend him for 1 day, and then he's gone the next day.
Yeah.
And then what happened? Why not? Was this senior VP sanctioned? He's overall, he was responsible for the area. Why was this gentleman singled out for dismissal? Yeah, that one. But they lost anyway, because of course, it was unfair.
Yeah, because that whole action, when you read the case, that was not gross negligence.
No, it wasn't. No.
That was not. But they just wanted to get
Right.
That-
It was right. And on page 10, number 34, it says, in order to be summarily dismissed on the ground of gross negligence, the respondent had to honestly and reasonably believe that the appellant himself was personally grossly negligent in his own conduct. It was not sufficient for the respondent to believe that the appellant was collectively negligent with all persons in the casino cage operations, and such collective negligence led to loss. The appellant must be personally grossly negligent.
It's not a collective thing, it's personal.
Right.
Yeah.
So he won.
He won. That was good.
Yeah.
Who's next? We're almost there, eh? Yes, what's your name is next. Let me see if I can pronounce this. Akua?
Yes.
Yes.
Okay, so I have First Caribbean International Bank, Bahamas, and Shawanda Jones. This took place in the Court of Appeal, where First Caribbean was the appellant and Shawanda was the respondent. So the case dealt with an appeal from the Industrial Tribunal's decision, wrongful dismissal, summary dismissal, breaches of the Employer's Code of Conduct, and sections 31 and 33 of the Employment Act. So a summary of the case: after being employed with the appellant for 16 and a half years, the respondent was dismissed from her employment on November 5th, 2012. The background to her dismissal in summary is that in the course of her employment, she was required to travel to St. Martin in June 2012. As is customary, she was entitled to a per diem for meals and transportation in the amount of $460. The respondent was also the recipient of a corporate credit card. Before her trip, she withdrew $450 from the corporate card to constitute her per diem. While in the Miami airport in transit to St. Martin, she realized that the funds obtained from the corporate credit card were missing from her purse. Subsequent thereto, the respondent obtained an additional $460 as her per diem from a bank employee in St. Martin. The respondent signed as acknowledging receipt of the funds, and there was no indication that the funds were to be repaid by the respondent, and it was not repaid. So the appellant, First Caribbean, conducted an investigation into the respondent's conduct and the receipt of the additional per diem. Following the investigation, the respondent was invited to attend a disciplinary hearing to discuss the breaches of the appellant's code of conduct. At the hearing, the respondent was found to have breached the code of conduct, and she was summarily dismissed. Thereafter, the respondent indicated that she wished to appeal the decision to dismiss her. The respondent then petitioned the industrial tribunal on the basis that she was wrongfully dismissed. The tribunal found that the respondent had indeed been wrongfully dismissed and awarded her $68,500.12 with interest. It was against this finding that the appellant appealed to this court. So after review of the facts, the learned vice president of the tribunal identified the issue to be determined as whether the termination was reasonably in the range of reasonable responses in the circumstances and whether the dismissal was wrongful. Thereafter, she went on to review the law relative to unfair dismissal, notwithstanding that the claim to be determined before her was in relation to wrongful dismissal. So of course, the decision by the tribunal was placed aside and the appeal took place. So when it came to the sum of $68,512 with interest, they heard on March 22nd, 2018, and they allowed the appeal and promised to provide reasons at a later date, which is now the appeal taking place by First Caribbean. So the bank identified their policy is that the employee, Sharonda Jones, would have breached. She would have breached the code of conduct for honesty and integrity and maintaining records. She would have breached First Caribbean's International Bank expense management policy, falsification of expenses. She would have breached the corporate employment expense card agreement and also breached the employee credit policy. So the case goes on to give a background on Ms. Jones. She was an employee from 1996. Her last promotion was to business support manager in 2010. She would have reported to Mrs. Jennifer Brown, who was the director of regional operations in the North Caribbean. And she was authorized to leave for a trip to St. Martin in June, between the 17th and the 23rd. So on June 15th, prior to her departure, her supervisor would have asked her if she would have received her per diem in the amount of $460. So Ms. Jones would have advised that she had the corporate credit card and she would have gotten her cash from the corporate credit card. So she would have had to complete an expense statement or requisition for her per diem, which she did not do. So instead of getting the expense statement, Ms. Jones would have went to the ATM and used her credit card to withdraw $150 on Thursday, the 14th of June. She went to the mall ATM to withdraw $150. On Friday, she withdrew $150. She went to Carmichael Road ATM, withdrew another $150. And then she went to the Prince Charles Shell gas station and withdrew $150. So, sorry, you following me?
I said, well, that sounds like you. Why would she do that?
So she's already not following policy. And then she's chopping up her expenses. So she failed to inform her supervisor that she was doing this. So on Monday, the 18th of June, while she was in St. Martin, and she had identified that she did not have the $460 she took, she advised the employee, Miss Sylvia Bailey, that she didn't have her per diem. So a general ledger entry was then signed for the respondent, acknowledging that she received her per diem and it was classified as business travel expenses. So when the respondent returned to Nassau on June 23rd, she submitted a employee expense report, and the respondent then went on sick leave in July. So she came back, submitted an expense report for the $460 or her per diem, and then she went on sick leave for 9 weeks after, 9.5 weeks. Okay. So, and at that point, she still didn't tell her supervisor that she had lost the money and she had to get the money when she just traveled off the island.
You believe the money was actually lost?
I do not believe the money was actually lost. But when the respondent did not return to Nassau, when she did not, upon her return to Nassau on the 23rd of June, subsequent to her sick leave, Ms. Brown had obtained an additional $460 per, yeah, when she didn't advise Ms. Brown. And so Ms. Bailey in St. Martin would have forwarded to Ms. Brown upon her request the expense statement that was completed there. So it was identified at that point that Ms. Jones never repaid the $460. And so it's at this point that she had broken the honesty and integrity expectations of the bank's code of conduct and maintaining accurate records and expenses. So the case outlines all of the breaches that she had there. So the appellant duly conducted an investigation, First Caribbean, into the respondent's conduct and her receipt of the additional per diem. The respondent gave a signed statement to Ms. Crystal Johnson, the respondent's investigator, on September 24th concerning the additional per diem. In the statement, the respondent admits that she did not repay the funds to Ms. Bailey, nor has she spoken to Ms. Bailey about repaying the funds. So there is no intention to repay. The respondent further admitted that she had been given a fair opportunity to respond to the questions asked of her. So the appellant completed an internal report outlining the results of its investigation, which was dated October 3rd, 2012. As a result of the report, the appellant forwarded a letter to the respondent dated October 10th, outlining the breaches of its policies, which it alleged the respondent had committed, and invited her to attend a hearing on October 16th with an employee representative to discuss the said breaches. So the disciplinary hearing took place October 16th in the presence of the union representative for managers, Mr. Timothy Adderley, where given opportunity to address the appellant's allegations against the respondent. A decision was thereafter made on the findings from the disciplinary hearing, and the appellant was held to be in breach of the code of conduct and all the prior listed codes of conduct that were identified. So by letter dated November 5th, 2012, the respondent was summarily dismissed by the appellant. The letter dated November 8th, the respondent's union representative, Mr. Adley, advised the appellant that he wished to file an appeal on the respondent's behalf and outline in detail the basis for the appeal. So the appeal went to the tribunal January 29, 2014, and the respondent petitioned the industrial tribunal for the finding that she had been wrongfully dismissed. The evidence before the tribunal may be gleaned from the decision of Honorable Marilyn Mayers, which is dated November 10th. The respondent testified that in December 2012, when she traveled to St. Martin for 7 days, the respondent said that the appellant grants $60 per diem for travel and gives employees a corporate card in such instance. However, respondent averred that prior to the trip, she was told by another senior or same level employee that there were issues in using the corporate card when traveling abroad, and that there was a $150 daily cash withdrawal limit available. She said that she therefore decided to withdraw the cash prior to the trip and did so on 3 instances.
But hold on. If she withdraw prior to leaving, wouldn't those withdrawals be in B dollars?
Yes.
So why would you withdraw before you leave?
And then she didn't notify her supervisor that she withdrew them. So when she went, but my question was, when she went to St. Martin, did she get $B cash, $450 or the $460?
Gotten US.
She would have gotten she would have got US.
Yeah.
Oh, wow.
So the B dollars that she got home, she left that to pay a bill.
Okay. Well, throughout the case, I realized she never disclosed that she lost the money in the airport.
She did not lose the money in the airport.
No.
No.
And I was trying to be empathetic. Okay. So she didn't lose the money. But she discovered, the respondent said, and she did say that she discovered the funds $450, which she had withdrawn, was missing her purse. She said that she had no other cash with her and determined that to return to Nassau would be too costly. So she continued on to St. Martin without the cash. So the respondent further stated that and my question too was, wouldn't it be too risky to travel without cash?
Of course.
So why would you even go forward to travel an unknown place?
She had to pay she had to pay some bill.
Yeah. Yeah, that was evident in this. So Ms. Bailey then gave the appellant the sum of $460, which according to the appellant, she intended to repay upon her return to Nassau. According to the respondent, upon her return to Nassau, she was unable to inform her immediate superior, Mrs. Brown, of the events of her trip because Mrs. Brown was busy. She said that she had other work commitments to attend to as she was preparing to go on leave due to an upcoming surgery. So this is where things got interesting. The respondent and her estranged husband had a mortgage with the appellant. The respondent had notified the appellant of her marital issues and that she had left the mortgage marital home for more than a year. The appellant deducted the entire mortgage payment from the respondent's salary, which is paid bi-weekly, into her employee account. According to the respondent, while on sick leave, the appellant froze her ATM card, but not her estranged husband's, which was attached to her account. She said that her husband withdrew funds from her account without her knowledge, and that this led to her being unable to repay the funds obtained from Ms. Bailey in St. Martin. So my question was, why did that have to be disclosed?
I agree with you.
Yeah. So according to Ms. Brown in June 12, she asked the respondent to visit St. Martin to review operations. Based on this request, she would have had to approve through a travel agent for her to go to St. Martin in these states. Ms. Brown stated that the expense policy of the bank requires that whoever is traveling should prepare a travel requisition form prior to departure for their per diem, being their meal allowance and taxi fares, and present it to their manager for approval in order to get that cash up front. She said that as the travel requisition form was not presented to her, she became concerned. And so on Friday, when the respondent came to say goodbye, she asked the respondent, "What about your cash?" The respondent response was she was going to use her corporate credit card for a couple of days, but did not say that she had already withdrawn the funds. Mrs. Brown said that she had to pay her bills.
That's right.
Yeah, and she had cash in hand, so she used that. She didn't disclose it. Mrs. Brown said that she asked the respondent to complete the expense report and to let her have the report on St. Martin prior to her departure. Mrs. Brown noted that the bank's guidelines required that report to be provided within 5 days after the employee returned, hence her request. The expense report was provided dated the July 3rd, which was after the allotted time. So fast forward to the investigation and disciplinary proceedings. The respondent provided a full written report dated September 24th, wherein she set out her version of what transpired. She was additionally afforded a hearing at the disciplinary proceedings, which took place on October 16th. There was the adjudicator and human resources manager as chairperson for the meeting. The respondent and note taker. The respondent also had a representative in person of the president of the managers union and Mrs. Brown. So the tribunal's decision. After review of the facts, the vice president identified the issue to be as determined, whether the determination was reasonably in the range of reasonable responses in the circumstances and whether the dismissal was wrongful. The learned vice president then went on to review the law, for some inexplicable reason, contained a review of the law relative to unfair dismissal. So the appellant has not provided any evidence of a particularized claim for unfair dismissal. So the vice president goes on to describe what is wrongful dismissal and how it occurs and what conditions had to remain for it. So decisions and discussion and findings, the claim which the tribunal was asked to deal with was clearly one based on wrongful dismissal, and that the appellant's defense was that they were entitled to summarily dismiss the respondent due to her conduct. It followed that the relevant provisions of the Employment Act were those which deal with such a claim. An employer may summarily dismiss an employee without pay or notice when the employee has committed a fundamental breach of his contract of employment or has acted in a manner repugnant to the fundamental interests of the employer. So it goes on to list the necessary breaches based on the appellant's position in this matter essentially was that the bank has lost trust and confidence in Ms. Jones and her ability to execute her duties and responsibilities as an employee. So of course, she was in a management position, so she was expected to carry out her duties in a particular way, and of course, in a higher level of trust and integrity. And so the misconduct would have applied to her, gross misconduct would have applied as the fact that she did not declare that she had accessed the funds twice for her per diem. So in short, to summarize, so the Court of Appeal made a decision, in my view, the claim before the tribunal was clearly a claim for wrongful dismissal, and the appellant was relying on its right to summarily dismiss the respondent for breaches of her employment contract. The vice president's specific finding, which was relevant to the issue, was that whether the respondent genuinely believed the applicant was guilty of the alleged misconduct. There was, before the tribunal, clear evidence of a full investigation by the appellant in compliance with Section 33 of the Act. The evidence indicated that Mrs. Brown made inquiries and a report was made to Human Resources Department. Prior to the report being published to HR, Corporate Security would have interviewed the respondent and Ms. Bailey as a part of the process. So based on the procedures, a full investigation was done. And although the tribunal would have awarded judgment for Ms. Jones, it was evident based on the Court of Appeal that they found that she did breach the code of conduct, and it was gross misconduct on Ms. Jones' part. So in the circumstances, the appellant was clearly entitled to summarily dismiss the respondent, who they found to have breached its internal policies and acted in a manner repugnant to their fundamental interests. We are therefore unable to sustain the vice president's decision in this matter and order that the appeal be allowed and the decision of the tribunal granting an award for wrongful dismissal be set aside.
And you notice in this case,
So the 68,
go ahead.
sorry, you said?
No,
No, I was saying the 68,000 that they awarded her would have to be set aside. But what would happen in this case?
oh, they'll have to go back and recalculate what she should be given.
Wow.
And it surely wasn't going to
So
be
she
that.
would get something. So it would be something, okay.
But I was saying that
Yeah, I was empathetic.
who you were, I was not.
I was.
To that ATM. She went to different ATM machines. She didn't go to one ATM machine and withdraw money, you know.
No,
Right.
All
no.
machine.
Who
One.
that woman is a thief, man.
That, but she had worked there for 16 and a half years. You're gonna lose your job.
She
for
don't know.
$40.
Mhm.
Oh, yeah, that
No,
Yeah.
no.
makes sense.
Yeah,
And just like in the
yeah.
other, the judge said she may have placed herself in a better position if she had acknowledged that she had committed the breaches,
Right.
She did the wrong. Yes.
that her conduct was not consistent with her character, but driven by her circumstances, her illness, and her marital and
Mhm.
financial issues. This would not have come to this
Very
level.
true. That's true.
They're ready
True.
for business. So it ain't as if she had to hide that. They know she
Mhm.
had financial issues.
Mhm. Yeah, they were aware of that.
Right.
I guess that's why that was brought up in the case.
Right. So just like the woman at BPL who had the man in the room, she should have thrown herself to the ground and begged for mercy. Maybe they may have demoted her, but she would have still had a job. But to have the whole court sit down and watch the video with you raising your leg and doing this and feeling your breast, no, that's humiliating. And if I think correctly, I think she was married, you know.
Oh, really? Wow.
I think she was.
Mm.
Oh, wow.
Yeah, these people is do these things, and you gotta fall down on your knees for the mercy of your employer, especially when you're wrong.
When you're wrong,
Mhm.
agreed. Yeah.
They were wrong.
I still, for BPL, I still trying to picture all of this happening in front of your employee, in front of your coworkers. That's the part what got me baffled.
Yeah, but she did it. Did it in front of all of her co-workers.
Wow.
And I guess once he would have come in, then most of them probably left.
Mm.
You see? Because they knew what was going on. That behavior was not expected of a woman who worked for 24 years.
First
in
one, yeah, agreed. Agreed.
No.
I definitely agreed.
No, she was not a baby.
Yeah.
No. Mm-mm. Her conduct was just totally off.
Mm-hmm.
No, can't do it. Well, it's 8:30. You want to leave Cecilia Cash and Gray Cliff, or
I'll just say that this case is I found it quite difficult to stay interested. It's a little boring. I'm not gonna lie, in my opinion.
I'll do this one next week.
Yeah, I mean, I got through it, Miss Archer, but like I said, I found it was long, very detailed, but boring, you know?
Oh, okay. Let me see if I can find you something exciting.
Okay.
So
Thank you.
next, we're gonna look at employee termination, redundancy, and dismissals around the same, in the same area, but I have more cases that we can look at and see what happens when persons are dismissed. Okay, so I'm gonna
Okay.
send you all more cases. Some people are absent. I don't know why. Who's missing? Quite a few people missing. What happened?
I don't see LaFleur
I don't.
and
Yeah.
there's another lady, begins with H. I don't see her name.
H.
It's another lady. I don't see her name. I can't remember the name is now.
And Hall. No, not Hall.
Oh, no.
No. I don't see her name on my list here from the last class. No, I don't see her. But LaFleur is missing. But she sent me a note. All right, so I'm gonna send you some more cases. You want me to do Cecilia Cash, or you've read it already? You want to present it or no?
I mean, I can present it. I don't have a problem doing it, but like I said, at 8:30 tonight, I found it was a boring one. So y'all
Okay.
might fall asleep on me.
Yeah, we'll leave it. We'll leave it.
Okay, I mean, it was very detailed, like they went into a lot of details, but yeah, wasn't as
Okay.
exciting as any of the others that we heard tonight.
Yeah.
I agree.
Okay, and you notice that there's a lot where the company, where the employer is saying that they've lost trust and confidence. Remember when
Yeah.
we went first,
Yes.
earlier, first started?
Yeah.
Yes.
Trust and confidence.
Mhm.
I have one I'm gonna send. It's Kedra Bell versus John Bull. I don't think we did that one.
Didn't we?
Did we do Kedra Bell?
Yeah. Is she the one that?
No. No, we never did that
She
one.
went. Isn't she the one that traveled and was
On a
supposed-
vacation.
Right, but she was supposed to be out sick or something. Is that her?
No, I don't.
No, I
That
don't
was not-
remember that
okay.
one.
Yeah,
Alright.
that,
No, never.
that's Yeah, that's the one. But I have another one where they were drinking wine at a
Yeah, that's
party.
McCarty. That's Helena McCarty and John Bull.
Yes.
Mhm.
But I look to see what else that we
Two
could,
glasses of champagne.
yeah, I'm gonna look for that one. Let me see.
Okay.
This one is who? I have Sherry Brown. BPL.
There was
She-
one by the Court of Appeal and one by the tribunal.
Yeah.
There were two Sherry Brown and BPL.
Mm-hmm. So we have those we didn't do tonight, so we could do those next week. Who I had those assigned to? Hold on, where's my paper? Us Burnside and Cartwright.
That's who missing.
So yeah,
Inside.
Burnside and LaFleur. Those two missing. That's why. Yeah. So those will be the two for the two Sherry, the Sherry Brown and BPL versus so. Okay, but I'm gonna still find some cases that I can send to you all. And I'll see if I can find some exciting ones. How about that?
Yes, yes.
Okay.
You
I'll
like
find.
the juicy ones.
Yes, yeah. I like the juicy ones.
Mhm.
Like, so next week,
and
go ahead.
no, I found in rereading, because speaking for myself, I didn't get to read some of the cases, that others presented.
Uh-huh.
I'm like reading up to the exam, and in reading the cases, I found them to be interesting going through them. So I said, I see why you chose them for the exam.
Yeah.
And
Yeah.
so those were, so I all of those that were on, I thought were interesting.
Yeah. Okay.
So there seemed to be some really good cases, particularly when you know the companies, and in one of them I was
Mhm.
like, oh my gosh, I know this guy, right?
Oh, wow.
So yeah, no, they're quite interesting.
Okay. I know students normally complain, but to me, you reading the notes, you see what the law says, but how do you apply it? How does it work in real life?
Yeah.
I think that's what you have to take away from the class.
Yeah.
You know,
And some
you
of
can.
these- yeah, like you can see some of these things actually happening in like your organization.
Yes.
So it helps to have the reference point.
Mm-hmm. You could always just go back and look up your cases.
Yeah.
So, I mean, like after the class, if you want to, you can go through your cases, you could make notes on it, and you could have those as reference points.
Yes.
Have an investigation. What do I have to do to ensure that my employer wins? What are the steps I need to take? Is there anything that I miss? And you could go through these cases and you could see right from it what the court is saying needs to be done, what you didn't do, should do.
Yeah.
If you let's say you have you're a union representative, you have an employee, you should know now that depends on what it is, especially if it's gross negligence or something like that. You could say, you need to fall down on your knees, apologize,
Right.
and
Right.
people will, even if they demote you, the point is you still have a
Right.
job. You
Yeah.
can still
Make that recommendation. Yeah.
you can see
Okay.
the more you read, you'll see how the judges think. And so you begin to see how you can advise either from an employer side or the employee side. Because it really doesn't change. Yes, the facts may change, the issues may be different, but watch the way in which the judges make their determination.
And
It's
I
on-
thought also it's quite interesting that even with most of the same information, the tribunal and like, for example, the Court of Appeal would come to completely different positions,
Yes.
That's interesting as well.
Mm-hmm. Yes, it is. So those are the things you have to look at. But I always find the cases really interpret for you what the legislation is. So when you read a section, let's say if you're at work and they say there was a violation of section 33 subsection 1, you know from your cases how the courts have interpreted that. And that's what's key. to imply, to interpreting the employment legislation. How is the court, how have the courts interpreted? And notice it's based on case law.
Yes, yes.
And if you,
Yes.
the more of them you read, you begin to see the cases, the Bahamian cases or the English cases that are the foundations, what you call the bedrock of where these sections in the act come from. You understand it more. All right, so we'll
Yes, ma'am.
read cases for next week. I'll find some more to send to you all. I'm making a note now to
Okay.
say writing.
Okay,
Okay,
thank you.
thank
Okay.
you.
All
All
right.
right,
Have a good
Okay.
evening.
thank you.
Ms.
Okay.
Archer, before you go, a question
Mhm.
about the capstone,
Okay.
if I may.
Go ahead.
Are we gonna discuss that in any detail or the question?
We can for next class. We can.
Okay, please, thank you.
Okay, since we have two persons missing.
Yeah, okay,
discuss- Okay, not a problem.
great. Thank
Okay.
you.
Okay, all right.
Okay, thank you.
night.
Good night.
Bye, good
Good
night.
night.